Chapter 16, Action of Truvor, Sec. 86, Action of Truvor. This action was formerly one of the actions included under the action on the case, and was founded upon the supposition that the goods were lost and that the defendant came into their possession by finding, and that he afterwards converted them to his own use. It was severed from the action on the case in 1542-3, but did not receive its precise form until 1551. The allegation of finding was a mere fiction, the conversion being the only material fact. Lord Mansfield thus describes the action: in form it is a fiction, in substance it is a remedy to recover the value of personal chattels wrongfully converted by another to his own use. The form supposes that the defendant might have come lawfully by it, yet by bringing this action the plaintiff waives the trespass. No damages are recoverable for the act of taking, all must be for the act of converting. It lies in general to recover damages for the wrongful conversion of personal property, to which the plaintiff has the title, either absolutely, as owner, or specially, as a carrier, or a sheriff who has taken goods on execution or the like. The object of the action is the recovery of the value of the property as damages, and not the recovery of the property. The conversion is shown by an assumption of property in, or exercise of authority over, the goods of another, inconsistent with the title of the rightful owner, or in exclusion of his right. Demand for the delivery of the goods must be made before the action can be maintained only when the goods came into the possession of the defendant lawfully, and need not be made where the taking was wrongful. Sec. 87. Origin and History of Truvor. The action of Truvor was created by virtue of the authority of the Act of Westminster 2nd. It was an offshoot from trespass on the case. The action derived its name from the French trouver, meaning to find. The gist or basis of the action was that the complaining party had lost his chattel property, and that the defendant had found the same and unlawfully converted the same to his own use. But this was a pure fiction upon which no issue could be taken. The action before its final development is found in three different forms. In its ancient form it was called an action for a chaussée, a common illustration being that of an animal taken as an estray. If within a year the loser made claim, and produced proof of ownership, paying for its keep, and the finder refused to give it up, the owner might count against the possessor of his res aderata, or chaussée, that is, his chattel gone from his hand without his consent. Though it is conceded that the averment of finding the chattel found in the action of Truvor is a mere fiction, and that there is no such essential fact present, we see by looking at the parent action of détenu Truvor, there was an element of truth in the finding of the chattel charged against the defendant. The earliest reported case in which a defendant was charged with converting to his own use the plaintiff's goods, is said to have been in 1479 in the reign of Edward IV. The plaintiff declared that he bailed certain tankards of silver to the defendant to take good care of, but that he broke them and converted them to his own use. The very earliest cases do not show that the allegation of losing and finding was ever considered as material or essential. The reformation of the common law procedure by the Hillary Rules of 1834 did not disturb the fiction of losing and finding involved in the action, but it remained an essential element as late as 1852. When the Common Law Procedure Act was passed. The less ancient action was designated as détenu Truvor, and is illustrated by a case of a lost horse reported in Keene's Cases on Pleading, page 182. The complaint recites the loss of the horse, giving its description, the finding by the defendant and his refusal to give it up upon proper proof of ownership. It states the damages as 20 shillings. The history of the action is the traced in which the court points out the distinction between the count for a chaussée and détenu Truvor, as being that in the former it is the plaintiff who finds the chattel in the defendant's possession, while in détenu Truvor, the finding alleged is by the defendant. Passing over the doubtful question whether détenu Truvor in the King's Courts was borrowed from the action of chaussée, or was developed out of détenu upon a general devenorant ad manus, the opinion is expressed that there is no doubt that détenu Truvor was the parent of the modern action of Truvor. It only needed the averment that the defendant converted the chattel to his own use, to produce the count in Truvor. Sec. 88. The elements or essentials of the action. In course of time the nature and form of the action assumed a different aspect, the important question being as to the nature of the wrong, the conversion, complained of by the action. It was stated in the early case of Cooper vs. Chitty, reported in 1 Burroughs, 31, decided in the King's Bench in 1750. The case defining the nature of this kind of action, trivia, and the grounds upon which a plaintiff is entitled to recover in it, will go a great way towards the understanding, and consequently toward the solution of the question in the particular case. In form it is a fiction, in substance, a remedy to recover the value of personal chattels wrongfully converted by another to his own use. The form supposes that defendant may have come lawfully by the possession of the goods. This action lies, and has been brought in many cases, where, in truth, the defendant takes them lawfully and by trespass. The plaintiff, if he thinks fit to bring this action, waives the trespass and admits the possession to have been lawfully gotten. Hence, if the defendant delivers the thing upon demand, no damages can be recovered in this action for having taken it. Sec. 89. Possession, demand and refusal. The conversion of the property having been settled upon as the gist of the action, the scope and meaning of the term was gradually broadened and extended. There was, however, some difficulty in particular cases in determining the appropriate action, whether detenue or trivia, depending upon the nature of the possession and detention. It became the settled practice that it was not necessary to prove actual conversion in the first instance. Proof of a demand and refusal to deliver the chattels constituted prima facie evidence that the defendant had converted the property to his own use. Conversion and detention had to be proved, but in time the term conversion was considered to express and embrace any unlawful deprivation of the possession of property, without regard to what the defendant may have actually done with it. It applied to and embraced wrongful disposition. A refusal to deliver without legal excuse constituted actual conversion and not mere evidence of it. In an early case it is said, this is an action of tort, and the whole tort consists in the wrongful conversion. Two things are necessary to be proved, to entitle the plaintiff to recover in this kind of action: first, property in the plaintiff, and secondly, a wrongful conversion by the defendant. It was always the rule of law in common law practice that in order to maintain trivia the plaintiff must have a right of property in the thing, and a right of possession, and that unless both these concur, the action would not lie. Sec. 90. Election between trespass and trivia. As the wrongful deprivation of the possession of chattel property constitutes either a trespass or a conversion, it follows that the injured party may maintain an action for trespass or trivia. But if the complainant elects to sue in trivia for the conversion, he thereby waives his right to recovery of damages which he may have suffered in connection with the wrongful conversion. The damages awarded in the latter action are confined to the value of the goods. Sec. 91. Motive or intent of defendant. Lord Abinger in Fowles vs. Willoughby, 8M and W. 540, Keen's Cases, 191, said that it is a proposition familiar to all lawyers, that a simple asportation of a chattel, without any intention of making any further use of it, although it may be a sufficient foundation for an action of trespass, is not sufficient to establish conversion. This does not appear to be the law in modern times, as any wrongful interference with property without regard to intent or motive will support the action for conversion as long as the property is actually withheld, though there may be an intent to return it. Delivery by mistake by a common carrier renders the carrier liable for conversion. 167. Sec. 92. Form of declaration in trivia. For that, whereas the plaintiff, heretofore, to wit, was lawfully possessed as of his own property of certain goods in chattels, to wit, description, of great value, to wit of the value of dollars, and being so possessed thereof, he, the plaintiff, afterward, to wit, on the day and year, and at the county aforesaid, casually lost the said goods and chattels, out of his possession, and the same then and there came to the possession of the defendant, by a finding, yet the defendant, well knowing the same to be the property of the plaintiff, but contriving and intending to injure the plaintiff in this behalf, hath not as yet delivered the same to the plaintiff, although often requested so to do, and afterwards, to wit, on the day and year aforesaid, at the county aforesaid, converted and disposed of the same, to his, the defendant's own use, to the plaintiff's damage of dollars, and therefore he brings his suit. We now call an action for the recovery of money damages for the wrongful appropriation of property, an action for conversion.